Article 1256. If the creditor to whom tender of payment has been made refuses without just cause to accept it, the debtor shall be released from responsibility by the consignation of the thing or sum due. Consignation alone shall produce the same effect in the following cases. 1. When the creditor is absent or unknown or does not appear at the place of payment. 2. When he is incapacitated to receive the payment at the time it is due. 3. When without just cause he refuses to give a receipt. 4. When two or more persons claim the same right to collect. And 5. When the title of obligation has been lost. Tender of payment precedes consignment. The former is a preparatory act, while the latter is a principal act which will produce the effects of payment. Consignment is judicial, court appropriate, while tender of payment is extrajudicial, not legally authorized. For the debtor to be free from responsibility or obligation by the consignation of the thing that is due, these are the requisites to be observed. 1 is there is a valid debt and it really exists. 2. There is tender of payment and the creditor refuses to accept it without a just cause. 3. Consignation. 4. Notice of the consignation has been given to the persons interested in the performance of the obligation. Persons or parties interested were notified. When tender of payment not required. Tender of payment is not necessary before the debtor can consign the thing due with the court. If the creditor to whom tender of payment has been made refuses without just cause to accept it, the debtor shall release from responsibility by the consignation of the thing or sum due. Requirements for valid tender. 1. Tender of payment must comply with the rules on payment provided by Articles 1256 to 1258, or with the terms required by the contract in making such tender. The tender, even if valid, does not by itself produce legal payment, unless it is completed by consignation, meaning that unless consigned by the court, the debtor is still liable to the creditor. 2. It must be unconditional and for the whole amount due, meaning the debtor must be in consent with fulfilling his obligations in full and in legal tender. Therefore, it is paid in the currency deemed valid by law for settling financial obligations. 3. And it must be actually made, meaning the debtor's mere desire or intention to pay is not enough. The debtor must show his present ability to settle his obligations by showing an actual offer, or the thing or the amount due. James borrowed $25,000 from Juan. On the due date of the obligation, James offers to pay the obligation, but Juan refuses to accept the payment without any justifiable reason. In this case, James's obligation will not be extinguished until he has made a valid consignation. The refusal by Juan to accept the offer to pay without just cause will not have the effect of payment, but James will be relieved from payment of any interest from the date of tender. In the same example, upon Juan's refusal, James then notified Juan, thus, I quote, "I will file a complaint against you and deposit the money in the proper court of Pampanga on January 25, 1969 at 9:00 a.m. if before that time you do not accept my payment." Juan having refused payment, James went to the proper court, proved to the clerk of court satisfaction that there was valid tender of payment, that James, the creditor, unjustly refused to accept the payment, and that there was a previous notice of consignation. The clerk accepted the deposit. Thereafter, James gave notice to Juan that amount had been deposited in court.